Good morning, this is your Kelso Report for Thursday, January 24th, and I'm your host, Clark Kelso. Well, the Ninth Circuit has affirmed the decision of the Surface Transportation Board to approve a 35-mile extension of a railroad line in Alaska. The First District has reiterated its prior orders directing Pelican Bay State Prison to refrain from using racially preferential practices as a routine basis for controlling prison gang violence, and the Second District untangles priorities in a complex set of loans containing cross-default provisions. We begin with the Ninth Circuit. Over the years, Congress has granted rather extraordinary authority to the Interstate Commerce Commission and related federal agencies to regulate and support railroads and the expansion of the railroad system. It has been a 150-year love affair. That broad authority was on full display in Alaska Survival versus Surface Transportation Board, which involved an environmental challenge to the decision of the Surface Transportation Board giving streamlined approval to the construction of about 35 miles of new rail line between Port Mackenzie, located in Alaska's Cook Inlet, and the railroad's main line located near Wasilla, Alaska. The streamlined process exempted the railroad from the full licensing provisions that otherwise would have been applicable, and the board approved the project against a variety of environmental objections. The Ninth Circuit affirmed the board's decisions, largely deferring to the board's expertise and administrative discretion. On the environmental claims in particular, the court found that the board's environmental impact statement contained a detailed, thorough, and thoughtful discussion of the wetlands impacts and mitigation measures. Construction can now begin. We turn to a habeas corpus decision from the California Court of Appeal. Running a prison where most of the prisoners are members of rival gangs is, to say the least, challenging. Acts of individual violence are a daily occurrence, and maintaining control so that gang riots don't erupt is a constant concern. At California's highest security prison, Pelican Bay, the warden has adopted certain race-based practices in an attempt to respond to long-standing and constant hostilities between rival Hispanic prison gangs and their disruptive group affiliates, whose repeated efforts to attack each other at every opportunity threaten the safety and security of all the inmates housed at Pelican Bay and the staff responsible for them. In In re Jose Morales, the First District reiterated prior orders entered by the courts that prohibit Pelican Bay from using race as a proxy for gang membership and violence, and thereby discriminating in prison programs and processes on the basis of race, without narrowly tailoring its classifications to further prison security. For example, Pelican Bay racially segregates prisoners, and during extended periods of perceived threat and violence, denies family visits, work assignments, yard exercise, religious services, and other privileges to prisoners of one race, while granting those same privileges to prisoners of other races. The First District concluded that these practices were still unconstitutional and affirmed the trial court's order, reiterating its prior order directing Pelican Bay to refrain from affording preferential treatment to inmates on the basis of ethnicity, while permitting prison officials to separate inmates still on the basis of ethnicity if prison security requires it, so long as it is not done preferentially and is done on a short-term emergency basis only. We'll see whether the state appeals that decision to the California Supreme Court. Finally, in the area of commercial transactions, one of the fundamental principles of the law of secured lending is that, properly done, prior lenders generally have priority over subsequent lenders. That principle was the basis for the Second District's analysis in R.E. Loans versus Investors' Warranty, where there was a complex set of loans containing cross-default and subordination clauses. The plaintiff in the case had agreed to subordinate its existing trust deed to a new trust deed in favor of defendants, securing a note in the amount of $4 million. But ultimately, the defendant's new trust deed secured that note plus 2 other notes for a total of $21 million. The notes were cross-defaulted, so that a default on one constituted a default on all. And when a cross-default was ultimately declared, the plaintiff claimed that defendants had breached the subordination agreement because the loan secured by the defendant's trust deed now exceeded $4 million. The Second District rejected this claim, reasoning that the notes secured by the defendant's trust deed needed to be treated as separate loans. And as a result, plaintiff's trust deed was subordinate only to the $4 million loan. They shouldn't have been worried about the other ones. The agreement to cross-default the loans was an agreement solely between the defendants and their subsequent borrower. That agreement does not affect the plaintiff's right to protect its interest, which continues to have priority over the other loans. Plaintiffs just didn't realize they had priority. And that's it for today's Kelso Report. Have a great day in the law.